Senior Tips USA, the retirement form that may unexpectedly redirect your spouse's financial future to someone from your past. Stop for a moment. Close the extra browser tab. Set your phone down because what you are about to hear in the next several minutes explains one of the most overlooked and financially serious problems hidden inside the American retirement system today. And the most alarming part is that this issue may already exist quietly inside your own records right now, waiting unnoticed. Here is the situation: the funeral services are over, the meals from neighbors have stopped arriving, the children have returned to their own homes and routines. You are sitting at the kitchen table in a house that suddenly feels much larger and much quieter than before. You are doing what any careful and grieving spouse would naturally do in this moment. You are trying to organize everything. You have the death certificate in one hand. You have the official last will and testament in the other. Your attorney prepared it several years ago. You paid thousands of dollars to have it drafted properly. You have one simple objective for the day: transfer the $1.2 million retirement account into your own name so you can continue paying the mortgage, cover the property taxes, and maintain the household for the years ahead. Statistically, you may now be expected to live alone. You walk into the brokerage office. You sit down in the leather chair across from the advisor who has known your family for more than 15 years. He smiles politely. That careful, sympathetic smile financial advisors learn to use during difficult conversations. He turns the monitor toward you, and then his expression suddenly changes. The professional confidence fades. The smile disappears, and he quietly says the sentence that changes your financial future completely. Ma'am, you are not listed as the beneficiary. You laugh at first because obviously there must be some kind of misunderstanding. You were married for 26 years. You raised 3 children together. You have the will sitting right there in your hand. The document clearly states 100% of all personal assets, including retirement accounts, to my beloved current spouse. The advisor looks back at you and calmly explains the next part, the part that changes everything you believed about how estate planning works. In 1992, before you ever met your husband, he completed a one-page beneficiary designation form for his retirement account. He named his first wife. The form was never updated afterward. Under Federal Retirement Plan, rules connected to the Employee Retirement Income Security Act of 1974, beneficiary forms connected to retirement accounts may control who receives the funds, even if newer estate planning documents say something different. The will alone may not override the beneficiary designation already on file. The distribution was processed yesterday. Yesterday, in less than a minute, during an ordinary meeting on a Tuesday afternoon, decades of marriage were financially overshadowed by paperwork completed many years earlier. This is the outdated beneficiary designation problem, and it affects families across the United States every year. This is not some rare story that almost never happens. Somewhere in Ohio, a surviving spouse may be learning this information today. Somewhere in Florida, someone may be discovering the account has already been distributed. Somewhere in California, a family may be trying to understand how future bills and housing costs will now be handled. And many people never realize this issue exists until it is already too late. The estate planning industry often focuses heavily on wills and trusts, but many families do not fully understand that retirement plans and beneficiary-based accounts may operate under completely different rules. A family may leave an attorney's office believing everything is fully protected, while outdated beneficiary forms remain untouched inside retirement portals and insurance accounts created decades earlier. The legal system does not review the emotional history of the marriage. It does not measure how long the relationship lasted. It does not evaluate fairness or personal expectations. In many situations, financial institutions simply follow the beneficiary designation currently attached to the account. If the information on that form is outdated, the outcome may also be outdated, the three-layer structure behind this problem. Understanding how this system works is one of the most important ways to help protect your family from future complications. There are 3 major layers involved. Each layer plays a role in determining how retirement accounts and beneficiary-driven assets are distributed after death. Layer 1, the non-probate asset system. This is the foundation of the issue. In American estate planning, assets are often divided into 2 separate legal categories. The first category is known as the probate estate. These are assets generally controlled by the instructions inside your will. This category may include individually owned vehicles, personal belongings, and bank accounts titled only in your own name. When someone passes away, the will is filed with probate court. A judge reviews the estate. Creditors are notified. After legal procedures are completed, the remaining assets are distributed according to the instructions contained in the will. The second category is known as non-probate assets. These assets follow a different transfer process entirely. In many cases, they pass directly according to beneficiary forms or ownership contracts already connected to the account itself. The will may never control these assets at all. Financial institutions instead review the beneficiary designation currently stored in their records and distribute the money according to that information. Assets commonly included in this category may include 401k plans, traditional IRAs, Roth IRAs, 403b plans, 457 plans, pensions, annuities, life insurance policies, payable-on-death bank accounts, transfer-on-death brokerage accounts, and jointly owned property with survivorship rights. For many retirees, these non-probate assets represent the overwhelming majority of total household wealth. That means the beneficiary forms attached to those accounts may be just as important as the will itself. In some situations, those forms may have been completed decades earlier and never reviewed again afterward. Read that carefully. A large percentage of family wealth may ultimately follow paperwork completed many years ago rather than the estate plan created more recently. Layer 2, Federal Retirement Plan Rules. This is where the situation becomes even more important. Many workplace retirement plans in the United States are governed by federal law through ERISA, the Employee Retirement Income Security Act of 1974. Federal retirement law often controls how these plans are administered and distributed. Over the years, several major court decisions have reinforced the importance of beneficiary designations connected to retirement plans. Courts have repeatedly ruled that plan administrators generally must follow the official beneficiary form currently listed in the retirement account records. Even when wills or divorce agreements contain different instructions, outdated beneficiary designations may still create major legal disputes and unintended financial outcomes. This does not mean every case is identical. Individual facts and state laws may differ, but it does mean beneficiary forms should never be ignored or assumed to update automatically. Financial institutions usually rely on the plan documents and beneficiary records already on file. That is why regular reviews are so important. Layer 3, the divorce decree misunderstanding. This is where many families believe the issue was already handled years earlier. A couple gets divorced. Their settlement agreement states that each person gives up rights to the other spouse's retirement accounts. Everyone assumes the matter is resolved permanently. But if the retirement account beneficiary designation itself is never updated directly with the plan administrator, the old information may still remain active inside the account records for years or even decades afterward. Time passes. People remarry, families grow, children and grandchildren are born. But the outdated beneficiary form may still exist quietly inside the retirement plan system unchanged. Then one day, after an unexpected death, the surviving spouse presents the will or divorce documents only to discover that the retirement account still lists someone else entirely. The financial consequences can be devastating for the surviving household. The real-world financial impact. Abstract legal concepts often feel distant until actual numbers enter the conversation. Here is a simplified example showing how this type of issue may affect a family financially. John is 68 years old. He worked for an aerospace company in Southern California for more than 3 decades. He was married to his first wife, Linda, from 1988 until 1995. He later remarried Sarah in 2000 and remained married to her for 26 years until his sudden passing from a heart attack. His financial picture includes a personal checking account worth $100,000, a 401k account valued at $1.2 million, an employer life insurance policy worth $500,000, a Roth IRA worth $150,000, a joint checking account with Sarah worth $50,000, and a jointly owned home valued at $800,000. His will leaves everything to Sarah. But the 401k beneficiary designation created years earlier still lists Linda as the primary beneficiary. The life insurance policy also still names Linda. Now watch what happens. The jointly owned house transfers automatically to Sarah through survivorship rights. The joint checking account transfers directly to Sarah as well. The Roth IRA had updated beneficiary information and therefore transfers correctly to Sarah. The individually owned checking account passes through probate and eventually reaches Sarah after legal expenses and administrative costs. But the retirement plan and life insurance policy follow the older beneficiary forms that were never updated. Large portions of the estate may therefore transfer according to outdated paperwork instead of the more recent estate plan. The final distribution ends up looking dramatically different from what the family expected. The surviving spouse may suddenly face major financial uncertainty even after decades of marriage. The difficult truth many families never hear about. Many people spend thousands of dollars creating wills and trusts, but never review the beneficiary designations attached to their largest financial accounts. Estate planning documents absolutely matter, but beneficiary forms matter too. In many situations, attorneys preparing estate plans do not personally log into every retirement portal, insurance account, or brokerage platform with the client to verify current beneficiary information during the meeting itself. The documents are drafted, the binder is assembled. The family leaves believing every detail is fully coordinated. Sometimes everything is aligned correctly. Sometimes important forms remain outdated for years afterward. Why does this happen so often? Partly because attorneys may not have direct access to employer retirement systems or insurance portals. Updating a beneficiary form is often free and relatively simple. Drafting legal documents is where the professional work usually focuses. As a result, beneficiary forms sometimes receive far less attention than they should. The four-step review process that may help families avoid serious problems. This review process costs very little and may help prevent major confusion later. Step 1. Create a complete inventory of all non-probate assets. Write down every retirement account from every employer, both current and former. Include traditional IRAs, Roth IRAs, 403(b) plans, 457 plans, annuities, life insurance policies, payable-on-death accounts, transfer-on-death accounts, and jointly owned financial assets. If you lost track of an old retirement account years ago, contact the former employer or search available retirement benefit databases. Leave nothing off the list. Step 2. Log into every financial portal and carefully review the beneficiary information attached to each account. Check the primary beneficiary, contingent beneficiary, percentage allocations, and the date the form was last updated. Many people are surprised to discover outdated designations connected to former spouses, deceased relatives, or incomplete family information entered many years earlier. Step 3. Update outdated forms immediately if needed. Use complete legal names and confirm all requested identifying information is accurate. If you are married and choose someone other than your spouse as beneficiary for certain workplace retirement plans, additional federal spousal consent rules may apply. Review those requirements carefully with the financial institution or a qualified professional. Step 4. Coordinate your beneficiary forms with your overall estate plan. Ask your estate planning attorney whether your current beneficiary designations have been reviewed alongside your will and trust documents. If not, consider requesting a formal beneficiary review so the entire plan works together properly. One additional warning for workers with older retirement accounts. If your career began during the 1980s or 1990s, your original employer may have merged with other corporations several times since then. Retirement accounts may have moved between multiple plan administrators over the decades. Some older paper records may have been converted manually into digital systems years later. Mistakes can happen during those transitions. Beneficiary information can become incomplete, outdated, or incorrectly recorded. Contact the current plan administrator directly and request written confirmation of the beneficiary designation currently on file. Do not rely only on verbal confirmations over the phone. Read the document personally. Verify every detail carefully. The retirement system is generally designed to process the information already on file, not to investigate whether your family's circumstances changed over time. You must personally review and maintain those records yourself. The final reminder. If you are over age 55 and have experienced divorce, remarriage, or major family changes during your lifetime, consider reviewing your retirement account beneficiary form soon. The review may confirm that everything is already accurate and properly updated. Or, It may reveal information that needs immediate correction. Either way, checking provides clarity and peace of mind. Financial institutions will not always notify you automatically when beneficiary forms become outdated. Attorneys may not independently review every retirement account unless specifically asked. The beneficiary form currently attached to the account often plays a major role in determining who ultimately receives the funds. Make sure those forms reflect the family and priorities you have today rather than circumstances from decades ago. Review the forms, protect your family, preserve your intentions. The opportunity to correct outdated information exists right now. Nothing in this material should be interpreted as legal, financial, or tax advice. Estate planning laws, retirement account rules, and beneficiary regulations may vary based on state law, account structure, and individual circumstances. Consult a qualified licensed estate planning attorney or financial professional for guidance specific to your own situation.